All right, why don't we go ahead and get started? I'm Debra D'Agostino. I'm a founding partner of the Federal Practice Group. We're a boutique law firm located, well, I guess, headquartered in Washington, D.C. We've got attorneys all over the place now, but headquartered in D.C. Um, we are going to be 14 years old in September. We've been around for a little bit. I head up the federal employment law team. I've been doing this somehow since 2001. I don't know how I graduated law school that long ago, but here I am. And I've got partners who I've known for about 20 years as well doing this work with me. We also do some military law and government contracts, but today we're here to talk about federal employment law, obviously, specifically about the HHS RIF. So I want to talk about your legal rights, what options you have, what those options might look like, and answer a bunch of those questions that you sent in. Let's just, I guess, start with the federal litigation piece of it. I just want to cover a few points there, since for HHS in particular, it's really pertinent. So there's a case, State of New York et al. Versus Kennedy. That case is pending in federal district court in Rhode Island. And just the other day, on the 18th of July, the judge denied the administration's motion to vacate the preliminary injunction that judge had put in place, on grounds that the Supreme Court expressed no view on the legality of any agency RIF and reorganization plan. And that's what that case is about. So as of right now, there is still a preliminary injunction in place. The administration has interpreted that preliminary injunction to apply to the CDC, to the FDA's Center for Tobacco Products, to the Administration for Children and Families Office of Head Start and regional offices, and then the Assistant Secretary for Planning and Evaluation. There's also a case coming out of California. And in that case, they were also granted a preliminary injunction, which stayed RIFs in many, many federal agencies. That ended up getting appealed all the way to the Supreme Court, which just, I think it was July 8th, stayed the preliminary injunction that court had issued. So what that means is that now the administration can go ahead with the RIFs at the agencies involved in that lawsuit. What's going to happen with that, though, is messy to say the least. So just because the Supreme Court stayed the preliminary injunction does not mean it's game over. So what's happening now is the case is going through normal litigation. I think it's in discovery right now in California. And so who knows how long that case will actually take to be resolved. But it could very well be that we're looking at, next Supreme Court term, wondering what the final decision in that case is going to be. I'd say that at this point, our general mood is that, the Supreme Court is likely to allow the administration to RIF in the way that so far they're trying to do. But on an agency level, like this Rhode Island case, they're going to be looking at what that agency is doing. I think that the litigation will continue. I don't doubt that. And I don't doubt there's probably going to be more lawsuits filed as more agencies start to affect RIFs. But I think for HHS purposes and you guys right now, if you work at one of those four entities, including the CDC, your RIF probably is not going to be affected. But if you don't work at one of those entities, then probably your RIF is being affected. And so, like I mentioned, we did file what's called a request for regulation review. We filed several of those on behalf of, I'd say, mostly groups of employees out of CDC for whatever reason hired us to do that. But then we also filed, I know there were some groups from HRSA, and there was also sort of a broader request for regulation review where we just challenged whether or not HHS as a whole was following OPM's RIF regulations if it was very apparent that the RIF notices that you were all issued had so many errors in them. And so we know that in response to that, HHS did do some things, like they finally started sending out the retention register. I know that they did issue some corrected notices, not all. I know several of the groups of CDC employees we filed on behalf of were called back. But that process is really just challenging the way HHS went about the RIF. It's not challenging any individual employee's separation or the separation sort of as a whole. The MSPB did consolidate the request for regulation review, but regardless of what happens with the request for regulation review, the separations are getting affected by HHS, and that triggers many deadlines that I want to make sure you're all aware of. We did file an HHS-wide class appeal on July 2nd. We did that in conjunction with AFGE. And just to explain why we did that and where that's at, we did that because there was some case law from the 80s that said that if a court invalidates a preliminary injunction, the agency can act like it never happened and retroactively affect the RIF. And so because most of your RIF notices said the RIFs would be effective on June 2nd, we didn't want to risk that we would not get a Supreme Court decision until the following week, which actually ended up happening. We didn't get the Supreme Court decision until July 8th, which would have been 30 days after June 2nd if HHS made the effective date retroactive. So because of that, we wanted to make sure everyone's deadline was told in case HHS did try to pull that, which we certainly couldn't rule out. So we did file that class action on July 2nd. We have thus far gotten denials of class certification from the Atlanta regional office and the Northeastern regional office, but we're expecting others to come in soon. You know, we had no expectation that the board was going to take an HHS-wide class action and run with it. So we're not at all shocked that class certification is being denied. But like I said, we did that just in the worst case scenario that HHS tried to make the effective date retroactive. And we didn't want you to all be out of appeal rights if that happened. So that's sort of the status of that. Big picture, so far, the MSPB has not certified a class challenging a RIF, which is maddening. There's no other way to say it. We're just not anticipating at this point that they're going to be welcoming class actions, which, I don't know why they're making this so hard for themselves, quite frankly, and you all. But right now, it's not looking like they are going to be welcoming class actions. But so what this means for you all, what this means for HHS employees is that at this point, we are anticipating that we're going to have to file individual appeals, meaning each employee who's getting separated by RIF is going to have to file an MSPB appeal. And then what's going to happen is that we're going to file those with motions to consolidate, which we absolutely know will be welcomed by the MSPB. Consolidation of MSPB appeals is something that happens fairly routinely. We're certainly seeing it with the probationary cases, and we've seen it with the other classes that were filed and not certified. In those decisions, they said you can file individual appeals with motions to consolidate, and that will be welcomed. So at this point, what we are anticipating doing is filing individual appeals for folks, like I said, with motions to consolidate, which we anticipate will be granted. At this point, we are contemplating filing motions to consolidate probably by, I'm not going to say competitive area, but by the competitive area as it should have been drawn. And we'll get to that too. But I know that a big concern about how HHS has done this RIF is that they're calling competitive areas. So they're just defining them very, very narrowly to the branch level, which does not seem appropriate. I don't think we're going to try to consolidate by branch, but we might try to consolidate by the division or the office that those 10 branches sit in, and file on behalf of everyone sort of in that group. There's also a chance that it might make sense to just do it by sub-agency, right? File the CDC ones in the Atlanta regional office, file the NIH ones, for example, here in the Washington regional office. I know that there's issues with remote employees, which we can certainly work through. I suspect the board's going to realize that it would be a whole lot easier to deal with with remote employees if this was just a class action versus an individual appeal that's getting consolidated. Because does it get consolidated with the CDC employees in Atlanta, or if this person lives in Oregon, say, does it go to the Western Regional Office? What I'll say about that is, what's really important is that you get your MSPB appeal filed. If they decide it's at the wrong regional office, they'll send it over to the right one. That's always been the way they operate. So people don't need to get so swirled up about where they're filing it versus the fact that it's getting filed. Big question of who can file an MSPB appeal. I know there were a lot of questions about this. So let me start with talking about bargaining unit employees versus non-bargaining unit employees. Generally, the rule is that if you are under a collective bargaining agreement that does not specifically exclude the right to challenge a RIF, you've got to use that grievance process to challenge the separation. And I know, the CBAs have been written in all sorts of different ways. I've looked at many of them. A lot of them are clear as mud as far as what your rights are to challenge a separation by RIF. And there's a lot of ambiguity there. I'd say that what we're trying to do is be in dialogue with the unions and finding out how they think we should proceed. So I'd say if you're covered by a CBA, if you're in a bargaining unit, talk with your union and find out what they think your rights are. And worst case, you file an appeal and somehow it gets dismissed because you have another avenue for a remedy. But given the current climate, given the litigation going on about whether collective bargaining can, quite frankly, exist at all in the federal sector, I'm suspecting, probably one of the safest moves will just be to file the appeal, just to avoid potentially missing the deadline to file and not taking advantage of a right that you have. So competitive service, accepted service, you can all file. Probationary employees who were rehired since the big sort of mass termination of probationers, if you have a RIF notice that's been affected, you can file. Also, employees who've been forced into involuntary retirement can file. So if you are forced into a discontinued service retirement because of the RIF, that retirement is deemed an involuntary retirement and you can file a RIF appeal. We're also getting a lot of questions about time limits to file an appeal. And what the board says is that an appeal must be filed no later than 30 days after the effective date of the separation, or 30 days after the date of the appellant's receipt of the agency's RIF-related decision, whichever is later. So I know that many of you received a letter saying that your RIF would be effective, I believe it was on July 14th. And many of you did not, although it looks like they realized that they did not get a communication to you because they threw you on administrative leave and blocked your access. So it sounds like they threw a number of letters in the mail that say you are being separated, effective. I'm guessing July 14th is what we'll see the most. And so technically you have 30 days from the date you receive that decision in the mail, saying that you are being separated to file the MSPB appeal. From a practical standpoint, I'm nervous about that just because I don't want anyone having to prove, when they did or didn't get mail. It just feels messy. I mean, if they sent them by certified means, that's one thing. But if you're just, you go to your mailbox and there's a letter in there, it just seems easier and safer to file by the 30-day deadline, which should be August 13th, than to risk, having to file it on, say, the 15th and then having to argue that it was timely. I should say that also the class action that we filed on behalf of all HHS employees, although class certification was denied, what those orders say is that you now have 35 days to file your individual appeal from the date of the order. Ideally, we would get all of these filed by August 13th. It's counted in calendar days, not business days. Just that's generally how the MSPB and really any court works. And to file an appeal is really no sort of, mountain high effort. You do need to complete an appeal form. You do need to file that with the RIF notice as well, ideally with the decision that shows the effective date. On the form, you'll be asked a bunch of questions that probably aren't relevant, right? Like, are you alleging a, USERRA violation? Chances are the answer is no to that. But then you're also going to be asked to explain why the RIF was wrong. And while this can be amended, you can only proceed at the board with claims and affirmative defenses that you've raised in your appeal. So, I'd say that probably the most common question we're getting asked right now is, why should I hire a lawyer to file this appeal for me versus just filing it myself? And honestly, that's a big part of what it comes down to. We practice before the MSPB day in and day out. I've been doing this, for over 20 years now. The agencies are certainly going to be represented by counsel, probably multiple counsel. I saw it with the probationary employees. People filed their own appeal, and just didn't make the right argument, didn't challenge the right things, didn't challenge it in the right way. And again, it's not that we couldn't amend the appeal to clean it up, but it would certainly be easier if we have a nice clean appeal from the start. And again, with a proper motion to consolidate it, right? So what I'll say about consolidation is that we would love to be able to define whose appeal your appeal is processed with. I would prefer that we're the one making that call versus the agency getting to make that call, or even the board. We have seen some motions to consolidate filed by OPM in RIF cases. I'd say that, with anything, they're doing that in the interest of OPM, not you, right? And here, if HHS files to consolidate, chances are they're doing that for their own benefit, not yours. The board does have an e-appeal system. It is a clunky one at best. It does take a long time to get anything filed. And so what we're actually planning to do at this point is file paper copies of appeals, literally in a box with the motion to consolidate on top, with a list of, this motion goes with these, however many appeals it is, 40 appeals, 100 appeals, whatever the case is. And then what will happen is the board will have to docket those cases in the e-appeal system. But you all don't need to bear the headache of trying to figure out the e-appeal system, nor do we have to try to figure out how to get this many appeals through that clunky system. But we do expect that they would docket it in their e-appeal system, and that way you'll have the complete docket, you'll have all the pleadings, you'll know what's going on in the case. So let's talk about what we're seeing with the HHS RIF, what legal issues are jumping out. The board does have jurisdiction to rule on the big constitutional issues. So yes, those are being raised in federal court. Yes, I suspect that ultimately that's where they're going to be resolved, but the board does have jurisdiction to rule on those issues. So I believe that we should put them on the table and we should raise those concerns. I don't think there's an advantage to not raising those concerns. I think the more avenues we have to attack this, the better. Why not bring it? I think there's also a good argument that this was not a bona fide reorganization. It would be HHS's burden to show that it was. Just a few examples. It looks like they eliminated work that is required by statute to be done by this agency. It looks like they did not follow their own policy for how a reorg should be done. It doesn't look they had the approvals that are supposed to take place in a reorg. We've also, have evidence that work that Congress fully funded to get done is being taken away. Whether those claims ultimately save the day, I certainly cannot predict, but I think we should really put whatever we can at it, because who knows, right? Who knows if the board is going to take up that issue? Who knows if the board's going to say, we're going to wait for the court to rule on this. We don't know. I'd rather be safe than sorry. I'll put it that way. Another big argument that we'll raise is that the agency, HHS, did not follow the RIF regulation. And so the competitive area drawing is certainly one example of that. But there are others as well. I'd say that the errors in the HHS RIF notices are extraordinary. I don't think any other agency has botched it quite as bad as HHS. What I'll say about that, though, is if we are appealing to the MSPB, a separation by RIF, to have a procedural error sort of win the day, we have to show that it was a harmful procedural error. So what that means is that the procedural error mattered. And what I'm concerned about is that if HHS is able to say these competitive areas were properly drawn and we eliminated the entire competitive area, then it doesn't really matter where you're ranked on the retention register. That's really going to come into play if they drew the competitive area wrong. So I think first argument needs to be the competitive area was wrong, and therefore the retention register does matter, and therefore the errors in the RIF notice are critical and are harmful to the employee. So fundamentally, I think that this issue of how the competitive area was drawn is going to be really critical because it is going to flow into the other problems with the RIF, which I guess leads me to my next topic, which is what happens at the MSPB. It does kind of follow a normal litigation track. So we file the appeal. We then get something called an acknowledgement order, which says we got your appeal. And typically it also says you've got, the agency has to file what's called the agency file. And then there's a deadline also to initiate discovery. We did see some deviances from that with the probationers. Instead of sort of sending us into discovery, they said, wait, we got to get this consolidation thing worked out first. So I do suspect what is likely to happen in this instance is that, that issue of who's in the group, whose appeals are being consolidated will get hammered out before we get into discovery. But we do have extensive rights to discovery at the MSPB. And so discovery is when, the parties ask each other for information. So we have the right to send over what are called interrogatories, which are really questions, right? Who was involved in this decision? We can also do document requests, extensive document requests. So we can request broad categories of documents, what went on between DOJ and OPM about what's to happen at HHS. All of these are discoverable, and these are all document requests we can make. But I'm certainly expecting that we might get into discovery battles. I don't know if this administration is just going to give us everything we're asking for. We also do have the right to take depositions. I would say that it's likely there's going to be depositions we'd want to take in these cases. And, what I think will sort of end up happening is that, if we are taking depositions in one case, we'll learn information that we can then use for other appeals, right? So, there is some efficiency by having one law firm handle all of these cases. Because we're obviously able to share information to the extent it's not information that that either is PII or is otherwise not something that you would consent to being shared. I'll put it that way. And there's also Democracy Forward, an organization that's trying to get all us or all the lawyers organized. They're also asking us to sign an agreement to info share. So if one firm is getting discovery first, sharing it potentially with another firm if the clients consent, and so on and so forth. So, this battle it's too big to fail, right? We've got to do what we can to take this on. Obviously it's as David and Goliath as you could get, right? I mean, it's you versus the federal government. Can't sugarcoat that one. That's what it is. So after discovery, what we would get into would then be either a hearing where witnesses would get up and take the stand, and there'd be direct exam and cross exam and all those things you expect to see at a trial. Or if it's a situation where it's really a legal issue that needs to be resolved and doesn't, the facts are all out there, then we can waive our right to a hearing and instead submit legal briefing. The government would get a chance to respond. We would get a chance to reply. Generally, we want to request a hearing in every case and then withdraw that as appropriate. And then after that, the judge would issue a decision. The relief available, by and large, is corrective action, right? So it's a rescission of the separation, which would mean retroactive reinstatement with back pay and back benefits. You would also get things like, leave back and that sort of thing. And if you did get another job, you're going to be able to choose, right? You can either go back or not. You can, say, I'm going to come back for one day, get your back pay and quit. I've always had, I feel like every few years I have a client who does that. It's like they get their job back, they walk in and say, I'm out of here, take their money and run, which by all means do that. But and you can unretire as well. Well, there was a question about how common are settlements in RIF cases. I would say that probably very uncommon, and a big reason is that you can't get part of a job. You either are reinstated or not, right? There's a lot of questions about the board lacking quorum. The judges are going these cases regardless of whether or not the board has quorum. Where this impacts things is if either side doesn't like the decision that the judge made. So if the judge rules against us, we have the option to either file what's called a petition for review, and that goes to the board, and we'd have to wait for the board to have quorum to have a decision on that. Or we can go to the U.S. Court of Appeals for the Federal Circuit, which sits, one level down from the Supreme Court. It's a circuit court like the, Ninth Circuit, Fourth Circuit, what have you. They have a very unique jurisdiction, including, different federal matters, MSPB cases being one of them. If we win and the government wants to appeal, under the regs, and I don't doubt we'll push it, but under the regs, the only option for the government is to file a petition for review. But it's not as awful as it sounds. The government can only file a petition for review if they've given what's called interim relief. And so what that means at the board is that the government has to reinstate you, has to start paying you, has to start giving you benefits, has to have you accruing service credit while that appeal is pending. So, under the first Trump administration, I had a handful of clients actually who got paid for years to not work. Some of them were even allowed to, get other jobs. One of them traveled around the world, what have you. But if we do win at the judge level and the government appeals, it's not all terrible. Let me get through a few of these other questions. Can you apply for unemployment? You certainly can. I would encourage folks to do that. If you don't have other employment lined up, what happens if you get reinstated retroactively is that the government has to pay back the state for the unemployment that they paid you. We have a few questions about what happens if you never received a RIF notice. And the answer, I believe, is that they cannot separate you. They are required to give you 60 days notice. And the notice is supposed to be the piece of paper saying, this is a notice that you'll be separated by RIF on this date. Here's the reason for the RIF, here's the retention register info and so forth. So if you were never issued that notice, but somehow they're still affecting your RIF, or maybe you didn't get a notice, you didn't even get a decision saying that the RIF is going to be affected, but you stopped getting a paycheck. I would say those folks should certainly appeal. Ideally, those cases get dealt with first, and those folks are reinstated. HHS would then likely be able to issue a proper RIF notice, but they're going to have to do that. They can't get out of that process. And also questions about resignations or retirements that occurred before receiving an official SF-50. In all likelihood, if you did make that election to leave, Even if it was under duress, even if it was after you had a RIF notice in your hand, you might be out of luck to file an appeal. We're going to be sending information to all of you. We're doing these on a flat fee basis right now of $1,500. Each individual employee does have to retain us. We do need to have, ethically, we need to have a representation agreement in place from you. And so we do have a link that will give you all the paperwork you need to do that, a link to make the payment. And that flat fee will cover, preparing the appeal, filing the appeal, preparing the motion to consolidate, and then if we've got to do any briefing on the consolidation issues, that will be covered as well. If we do get into discovery, what will probably happen is that we'll have to talk to the group about what that group fee is going to look like. We typically do this work off of what's called a fee advance, which is really just like what it sounds. So in other words, we ask for the fee advance to be paid before we do the work. I know folks are deciding between law firms right now, deciding if they want to hire a lawyer or not. Like I said, I do think that it is filing an appeal form, which maybe technically can be done without an attorney, but the other side is going to have a whole lot of attorneys backing them up, and I do think it's going to make a difference to have experienced counsel by your side versus trying to navigate this alone. I consult every day with attorneys across the country who might be employment lawyers, right? They've been doing employment law for 30 years, but this MSPB stuff is just weird and different and foreign and hard to navigate. And we've been doing this work forever and do it every day, all day. So, I do hope that we're able to provide value to everyone who decides to hire us. But I do want to thank you all for your time. Thank you for joining us today, and look out for a communication from us. All right, take care, everybody.